Hello, thank you for visiting the Your Family Lawyer Videos channel. My name is Mac Pierre-Louis, attorney at law and mediator. I'm the managing attorney at Pierre-Louis and Associates PLLC, a Houston law firm focused on civil and family law. And today I have my colleague,
Glenda Clausell. I'm an attorney in Houston, Texas at the Clausell Law Firm, and my practice area is estate planning, probate, and business law.
Okay, and I can be reached at macpierrelouis.com, my website, and Glenda.
My website is www.clausellawfirm.com.
Okay, and all our biographical information and our contact information will be listed on those sites. All right, so today we're getting into a topic that people sometimes Google or search for, and that involves prenups or premarital agreements or postnups or postmarital agreements. And I'm wanting to have a discussion with Glenda today just to answer some of the basic questions and queries people might have when they come to a lawyer to try to get information on a prenup. So let's get started. Glenda, what is a prenuptial agreement?
A prenuptial agreement is an agreement between two engaged parties, people who are planning to get married, which maintains or changes the character of property. For instance, anything that you own prior to marriage is considered separate property. But once you marry, it becomes community property. Now, if there are instances where you want that property to become separate, then you enter into a premarital agreement. A postmarital property agreement is for those that are already married and want to change or maintain the status of some property.
Okay, so and keep in mind, we're talking about prenups and postnups under Texas law.
Exactly.
Okay, because a lot of states have their own laws regarding this subject. But what are some typical scenarios or examples or instances where somebody might want to come and do a prenup with an attorney?
Right. As most of you know, Texas is a community property state. So there could be instances where both parties are interested in a prenuptial agreement. It could be an instance where they are marrying later in life and they have adult children and they want to make sure that certain assets remain separate for the benefit of those children. It could be instances where there are blended families and both parties, again, are interested in having a prenuptial agreement. There also could be instances where a financial level, there are parties who are not on the same footing equally, meaning you have one that has a higher earning potential, higher income, and a different tax bracket than the one that they're marrying.
Okay, and before we get into some of the requirements of a prenuptial agreement, we have to admit that this whole subject has its own certain kind of taboo in our society. So what do you think are some people's concerns when they hear the words prenup or postnup agreements?
It's the precursor to a divorce. So basically you're setting yourself up for a divorce because you're maintaining separate something while you're married. But it's not, in most instances, it is a meeting of the minds between the parties that they want this prenup agreement or the post-marital property agreement because they want there be a benefit to their children and grandchildren. So in a lot of instances, you have post-marital property agreements or post-nups because both parties are at the point where they want to make sure that certain assets remain with certain members of the family.
So needless to say, there are plenty of marriages that thrive and are very successful even though the parties have prenuptial agreements in place or postnuptial agreements in place that they do together during their marriage, right?
Right, because in the state of Texas, most agreements are post-marital property agreements. Again, it's not something you do because you know you're getting divorced. It's something that you're doing just to protect certain assets for certain members of your family. Okay. So there just shouldn't be a lot of negative connotation, but I do understand that we hear all the horror stories, and that's what's in the public eye or ears.
Yes, and sometimes those horror stories might include where the person who is engaged to be married is being pressured to enter into a prenuptial agreement by somebody else, usually a member of their family. Have you seen that?
Right, yes. There different categories or types of people who are interested in premarital premarital agreements. We talked about the first instance where both parties are interested in it, but there's another group of people, say for instance, one party who's from a more wealthy family, and their parents or aunts, uncles, grandparents are suggesting in some instances they may be trying to bully them into a premarital agreement. And again, it's basically the way it has to be handled. Counsel must be involved for both parties, and there has to be consent. The premarital agreement in and of itself is a work between the lawyers and the engaged couple. It is something that is drafted with each party's benefits in mind and what they're wanting long term.
Correct. And so that then begs the requirement that there should be attorneys involved.
Definitely.
In order to guide people to make good, sane decisions without duress or pressure.
And outside influence. And the lawyer's job is to educate their client as to what the laws are in the state of Texas for community and separate property. And it's also to do the negotiation between the parties. And the parties include the engaged couple, not their parents, not their aunts and uncles or grandparents.
Okay, so let's turn now to what are some of the basic requirements of doing a prenuptial agreement, because it is a glorified contract, but like a will or certain other agreements that two people might come into to do, there are some basic requirements that must be satisfied in order for the prenuptial agreement to become enforceable later. So what are the basic requirements?
Right. First and foremost, there needs to be consent. You cannot have one party create a prenup and tell the other party that they must sign. Chances are they won't sign. And again, there's under duress. You should not give the other party the prenuptial agreement on the wedding rehearsal night. That is, again, undue influence, duress. The other issue is that the prenuptial agreement must be in writing. It must be in writing. And if there is one that you want to make sure that's enforceable, the suggestion would be to have lawyers for each party there to, again, educate and assist in negotiating and drafting the document itself, basically protecting the interests of their clients.
Okay, so then what makes the prenuptial enforceable? Well, when does it become enforceable?
Upon execution.
Okay. Now, sometimes when people are doing prenuptial agreements, they may also be doing a will or have had a will in existence. So while a prenup might give certain property away or make decisions on how certain property might be divided later on, a will give property away that will become effective at death. So how does a prenup and a will intersect?
What you have is you're looking at a will, trust, and a prenup. The prenup, again, it protects, it carves out particular assets and keep those with the person who wants to retain ownership. The trust titles the documents or the assets to another party. A will only takes effect upon someone's death, but the prenup and the trust are living documents. So while you're alive, these things, these assets can be manipulated and they can be moved along to someone else. That's basically the intersection. If there were, say, for instance, in a will, a opportunity that everything in the will goes into the particular trust, that in and of itself would be an assist to the prenup. But again, the trust does not need to be in effect only because there's a will. The trust can stand on its own outside of there being a will present, as a prenup does as well. Again, and the will is something that you necessarily would not do in conjunction with the will, but you can. But it is very time consuming to create both documents, or all three rather.
So in this discussion, most of the time we use the term prenuptial agreement. However, there is this other thing called a post-marital settlement agreement, or a postnup. So let's imagine the scenario where a couple is married. However, one of them, for whatever reason, seeks to enter into an agreement with their spouse to change the characterization of certain property that they have in the marriage. Perhaps change certain property from community get a position to separate or reverse. So tell the audience what the differences are basically between a prenuptial agreement and a postnuptial marital agreement.
The prenuptial agreement is prior to the marriage. Post a marital property agreement is after the marriage. Now, if someone after the marriage wants to retitle, recharacterize property from community to separate, that is what you utilize the post-marital property agreement for.
Okay. So how do you cancel a prenup or postnup agreement?
That's a very good question. What you would have to do is amend, or there be some sort of other agreement to revoke it. But again, there would have to be consent. There should be lawyers involved, again, to educate you about the process, what is happening, and there needs to be, again, in writing. Okay, so that's very important. To create a prenup, postnup, you need consent from the other party. It needs to be in writing, and strongly recommend that every party has counsel.
Now, I'm sure what a lot of people who are entertaining doing a prenup or postnup might have in mind is the cost of doing all of this, right? Because, you know, when people hear lawyers, they think of a great expensive fee. What can you say about the cost of these things? What have you seen?
Cost-wise, it's I don't know if it's optional, but cost-wise, you need to think about your particular circumstances. Again, every family, every pre or post-nuptial agreement, it's going to depend on your family circumstances, your assets, and what you're trying to do, or what the end result you're looking for. Cost, it ranges, again, so you're going to have to look at what your expectancy is, how complicated the process is, how many assets are involved, and how much work is going to be involved in it. Again, same thing with a trust. It's very time consuming, it's complicated, and it takes a little bit of time.
All right. Well, thank you, Glenda, for this discussion today. So again, my name is Mac Pierre-Louis, attorney at law at Pierre-Louis & Associates PLC. I can be reached at macpierre.com. And Glenda, you want to close this out?
Sure. I'm Glenda Clausell. You can reach me at contact us at Clausell Law Firm. I thank you very much.
All right. Thank you so much. See you next time.